Good evening. Happy Saturday. So while driving to the fish store, I was listening to my stream and I realized it is 3.5 hours long. So I figure I would give you guys a synopsis. So the first thing that we covered was DeCastro versus LVMPD. They do have a discovery plan. They have until May 15th to finish discovery. Then they have 1 month after that to file any dispositive motions like summary judgment. So, and then it'll get set for trial. So I don't assume, and they agreed to do some mediation. So I don't anticipate this going all the way to trial. Once I don't know. I don't anticipate it going to trial. It shouldn't go to trial, but Chilli's Chilli, and he might be able to force it to go all the way to trial before he loses. So that was DeCastro versus LVMPD. The second case we covered was the Turtle Boy case, his emergency motion for a taint team, for appointment of a taint team. Again, it doesn't make a lot of sense that he has to file an emergency motion. According to Turtle Boy's attorney, the government had already agreed to stay any review of the materials confiscated in the electronic devices pending appointment of a taint team. So I don't think that he's going to gain anything by filing this. He asked for a lot of things that I don't think he's going to get. What I do think he will get is I do think he will get a taint team because the government already agreed to it and he's entitled to it. And they're going to segregate out the attorney-client documents, the emails between Turtle Boy and any attorney, and between any attorney and Turtle Boy. Because, or at least any of the ones that they identify, because that's really the only way that they'll be able to make sure that the state doesn't get any attorney-client privilege documents. He tried to make an argument that there was some sort of a reporter's privilege that would protect his sources that are on those drives, etc. Any officers or what have you that might be disclosed by the discovery. I'm out in front of the fish store, by the way. So people might walk by. So anyway, he asked for a bunch of stuff. He's not going to get it. Like I said, he'll get the taint team, and he'll get the attorney-client privilege documents taken away before the state can see them, essentially, before the investigatory team can see them. And that's really it. And then finally, we went over several documents from the Springer versus the 7th Judicial District Court. It's retard fight. However, one thing I want to mea culpa on, all the talk about attorney or qualified immunity made me forget that, or I don't even know, I must have looked at it at some point in time because I went over the complaint. But in the complaint, they only asked for monetary damages from the 7th Judicial District Court itself, the entity. They didn't ask for it from any of the other individual plaintiffs, i.e. any of the judges. And so judicial immunity wouldn't apply, and qualified immunity also doesn't apply. But they were arguing qualified immunity. I'm like, well, wait a minute. If they're asking for damages, why don't you argue judicial immunity? But they're not. So mea culpa, I forgot about that. Qualified immunity doesn't apply. Judicial immunity still will somewhat apply because they're asking for injunctive relief against a judge. And you can't get injunctive relief against a judge unless declaratory relief either doesn't work or the court ignores it, one of the two. So if they get an order for declaratory relief and the 7th Judicial District Court judges ignore that declaratory relief, then they would be entitled to the injunctive relief. So the rest of it is all nonsense. Just to show you the level of retardation, you have 21 days from the date a motion to dismiss is filed to file an amended complaint. You have 21 days as a matter of right. The first time, as a matter of right, you have 21 days from the time that the defendant files their motion to dismiss or their answer. You have 21 days from that point, and you just file an amended complaint. And the defendants filed their motion to dismiss either on October 23rd or October 26th, because they fucked up and they split their motion to dismiss into two parts. So the court struck that and made them refile it. So they filed it successfully on the 26th, which was, on October 26th. Then on November 2nd, so that's like what, 5 days later? 6 days later, they filed a motion to file an amended judgment or amended complaint. Doesn't make any sense to me. The opposition. So the question is going to become, because they both make retard arguments throughout. The question is going to become whether or not the court is going to allow the plaintiff to file an amended complaint because they were allowed to file one by right, and it was just kind of nonsense that they filed a motion. It was just incompetence on the part of the attorney, is really what I'm trying to say. Or in the alternative, is the court going to, since there was a motion, is the court going to look at the amended complaint and in deciding whether or not to allow the plaintiffs to file the amended complaint, look at the motion to dismiss and make a decision on whether or not the new complaint would fix any of the things in the initial motion to dismiss, etc. So my best guess, and this is just a guess, because this is, like you give two retards baseball bats and you throw them in a dark closet, one of them's going to come out and you don't know which one, right? Because it's two retards in a closet with baseball bats. So who's going to win? My best guess is that Springer's attorneys are going to get to file an amended complaint. Whether it's the redlined complaint, amended complaint that they attached to their motion, I don't know. But my best guess is that they will get to file an amended complaint. It might not look like the complaint. The court might be like, well, you get to file this, but you already lose on this point, this point, this point, and this point. Maybe. I don't know. Anyway, that's your synopsis. That is 3.5 hours boiled down to about 7 minutes. Thanks for watching. Have a great day.